All rise. Veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Good morning, everyone. Could the court officer please call the case?
Good morning, Mr. President and Your Honors. Situation in Uganda in the case of the prosecutor versus Dominic Ongwen, case reference ICC 0204-0115. And for the record, we are in open session.
Thank you. I ask for the appearances of the parties. Mr. Gumpert is rising for the prosecution.
Good morning, Your Honours. Ben Gumpert for the prosecution. With me today, Adeshola Adebayojo, Shkelzen Zanelli, Colleen Guild, Betty Hola, Puvudu Sachitanandan, Grace Go, Yulia Nuzban, Yasmina Soljanovic, Nikola Kaushik, Colin Black, Haida Duk, and Sanyu Degere. It's a full house.
Indeed. Thank you. Ms. Masida for the common legal representatives of the victims.
Good morning, Your Honors. Attending the hearing today, Ocholona Ransetsek, Caroline Olter, and I am Paulina Masida.
Thank you. And for the legal representatives, Mr. Manoba.
Good morning, Mr. President, Your Honors. James Mawira, Francisco Cox, and Listo Welato behind. Thank you.
Thank you. And for the defense, Mr. Ayena. Microphone, please.
Mr. President and Your Honors, today I'm accompanied by Chief Charles Acheleke Tako, Leon Bess, Gordon Kifude, Thomas Obov, Thibaut Bainovich, Eniko, Michael Rose, and Morgan. And today we have in court our client, Mr. Dominic Ongwen.
Thank you, Mr. Ayena. And it's now the turn today for the closing statements of the defense, and I give you the floor.
I thank you, Mr. President, and Your Honors. The outline of our presentation will run like this. I'll be going through the main areas of our concern in the case, laying the foundation for our case to allow my colleagues, Chief Tako, to handle areas to do with the plight of child soldiers, modes of liability, and the command structures, burden of proof, and evaluation of evidence, charges, and bar table motions. It will be drawing inferences from some of the key situations in the case. It will talk about intercepts and also touch on the matter of duress, and last but by no means least, the issue of the so-called wives. My colleague, Leon Beth, will be addressing fair trial issues. She will also be dealing in some aspects of burden of proof, especially in areas of affirmative defenses. She will be dealing with mental disease and defects defense under Article 31 of the Rome Statute. Mr. President and Your Honors, I rise to ask you to find Mr. Ongwen not guilty on all the counts and charges he's accused of. And this is because, Your Honors, after the last word of the prosecution and gleaning through my notes and what transpired in this courtroom, I find that they have not met the required standard of proving their case beyond the element of reasonable doubt. And Mr. President, as I said in the opening statement, it would be an understatement to say that the task before you in dealing with this case is the most unenviable one for the following reasons. Number one, never before has the world witnessed a conflict so profoundly complex in nature, steeped in metaphysics and spiritualism, as the one that forms the contextual basis of the case before you. Number two, considering the intensity and longevity of the conflict that bedeviled our country for more than 20 years, you'll find the navigation of this case rather complex and perplexing. Number three, you will have realized from what has gone through the witnesses before you that the technical approach on both sides of the protagonists and the sheer protraction of the conflict that spanned more than 2 decades are matters that needs very particular attention in order to appreciate what has been going on before you in this courtroom. It should not be left to our intellect, the intellect of counsels in this room, to carry the day. It should be appreciation of the factual situation of the court as perceived by your honors. That should determine this case one way or the other. The next one is, there is this rare thing about the mysticism with which the LRA prosecuted the war. This mysticism, your honors will realize, gripped most of the abductees with absolute awe and put them in total submission. And last but by no means least, your honors, we want again to raise our voice about the role of government, which finally facilitated the collection of evidence, in this case, in the conflict. And we also want to raise our voice about the neglect, or rather, the negligence with which the international community handled the situation in Uganda. And some of these members of the international community actively assisted the government of Uganda to perfect its war machinery in prosecuting war against an ill-equipped ragtag soldiers of the LRA to the detriment of members of the community. Your honors, Mr. Ongwen, who is before you, was just a child when he was abducted, brutalized and made into a fighter machine without a mind of his own. He is a victim, just like former soldiers who managed to escape and are now participants in this courtroom as victims. Your honors, whichever way this case is decided, Mr. Ongwen is entitled to all or any of the reliefs given to the other victims. He is a victim, and this point, Your Honors, is not contested by the prosecution. Neither has it been contested by the victim's counsel. This case is an indictment, therefore, of the government of Uganda, and indeed the international community, especially those countries who, instead of intervening to discourage the government of Uganda from prosecuting the war against the LRA in a manner akin to ethnic cleansing of genocidal proportions, instead funded and perfected its war machinery of mass destruction, considering the types of weapons the government of Uganda acquired from them and used to fight an ill-armed rebels within the civilian populations. When deciding who was responsible for the death in the IDP camps, Your Honors, I call upon you to consider the type of weapons, guns which were used, and particularly bearing in mind, Your Honors, that it has been shown through witness evidence before you that LRA just had light machine guns where you find bombs. Find fault with the government of Uganda soldiers. And my lords, I want to raise these pertinent questions that should be borne in mind when you consider this case. Number one, apart from the preliminary issues relating to fair trial violations, Your Honors are asked to determine, firstly, whether the accused qualifies as a victim. Although I know I have already said this is not contested. And then secondly, whether having been abducted as a 9-year-old child who spent nearly 27 years under LRA, Mr. Ongwen, at the stroke of midnight of his 15th birthday, transcended into an adult in terms of mind transformation, and thereby became a perpetrator of the crimes he's charged with. We submit that the prosecution has been at a tangent with the factual situation of this case. They turned their back to the core issues, which is the character of the LRA. They ignored the effect of spiritualism on the mental state of Mr. Ongwen. And when you're talking about the mental state of Mr. Ongwen, unfortunately, they think that what is relevant, the period that is relevant for assessing his mental state at the time is alleged to have committed the crime, was the child period. They have totally forgotten that it was the cumulative effect of what he went through immediately after his abduction up to the time of his escape and surrender to this court. And at this point, Your Honors, I think I want to put this matter of whether Ongwen was arrested, captured, and brought to court, or he actually surrendered. I don't have to emphasize this, Your Honor, Your Honors, but I know that it has been paraded either in the mass media or even in this courtroom, that Ongwen was arrested and brought to court. No. Evidence abound that Ongwen, at the glimpse of an opportunity, escaped from the grips of Joseph Kony, like he had been trying for many years, and surrendered to this court. And I think when you are considering this case, this must be taken into account. A responsible person who, of his own volition, with the mind-boggling threat by Joseph Kony about the ICC, nevertheless decided to come out of the bush and surrender. This has not been done by Joseph Kony and the others, including those who died, but who, before their death, had opportunity to surrender. Mr. President, we invite you to take special note that the prosecution has not shown that they took any effort to carry out any independent, factual investigation into the effect of spiritualism on the victims. They just, it was business as usual. To them, this is a normal case. But, Mr. President, I want, as I have always done, to emphasize that before you is a very special case, which even those of us who live in Africa, where it is believed that there is a line of brutality, there was nothing like that ever experienced. The intensity of the emphasis on spiritualism, the way it was applied, you heard even from the traditional spiritual practitioners themselves say was beyond them. Even the collective effort of all the witchcrafts, of all the witch doctors in Acholi land could not cope with it. They said they let him be because trying him would lead to your own death. This must be taken into account. Something very peculiar happened in this case. Kony is not an ordinary person. Once in a while, when I have had opportunity to address rallies, and people were blaming me for getting involved in this case, I would ask them, if you think that Kony is an easy man, he has invited me to go and see him again. Can I please offer an invitation to any of you who would like to come and meet Joseph Kony? I would pose that question to anybody in this courtroom. Most of them declined, because that is the thing about Kony that people in northern Uganda, believed. Ongwen, like the rest of northern Ugandans, believed the peculiarity and effectiveness of Joseph Kony's spiritualism. Mr. President, and your honors, somebody was trying to pour cold water on the concept that we coined here, that once a victim, always a victim. Your honors, this is predicated on the fact that a person like Dominic Ongwen, once he was arrested, and he was never allowed to be free, he became, the things that he did, like slavery of others, he's like, on Tuesday, Mr. Gumpert used a very interesting phrase, dog-eat-dog society. In our case, your honors, I think we would prefer the phrase man-eat-man society. That's the society we are talking about. That is the contextual background to this case. When Ongwen was abducted, he had no option. He was made a slave. That slavery continued until he left the bush. It is being suggested that he was a willing partner. How can you be a willing partner with all those injuries and those attempts he made to even extend to making contacts to the most powerful general in Uganda, the brother of the president of Uganda, Salim Saleh, to plan an escape? You have heard, Your Honors, that at certain points, especially during the charged period, Ongwen became a madman. And all the things that he was doing was aimed at actually dying. That included sometimes daring coin, sometimes defying some of coin's orders. And it has been argued, in a very obtuse manner, that these were hallmarks of evidence that Ongwen was a free-minded person. No. I've already talked about what people thought about coin. Even those who did not see him, those who saw coin knew better. For a man like Dominic Ongwen to dare him, that is not the behavior of a normal man. That's the behavior of a madman who has adopted suicidal tendencies. And his own words, and the words of some of the people, if by inference, some of the words of the people who testified here, Ongwen actually did certain things beyond the human. And why did he do this? He had lost his mind. All he wanted was to get rid of this human suffering around him. Die. That's a madman, in my view. Ongwen did not have a mind of his own. We submit, Your Honors, that you are faced with many vexing justice questions in this case. Number one, how should individual responsibility be addressed in the context of duress and collective victimization? You've heard, Your Honors, that one of the things that would befall anybody who attempted to escape, for instance, was that they would follow you to your village and mow down everybody in that village, your relatives, your neighbors, and so on and so forth. And the second one, is there any special consideration? This is another justice question. Is there any special consideration available to an accused, Dominic Ongwen, raised within a coercive environment of extreme brutality never seen in modern history? And thirdly, is it possible to achieve justice for both the accused, who is himself a victim, and for the victims of the crimes he is alleged to have committed? War crimes have been tried before. Situations of rebels fighting governments have been tried before. But I want to draw the attention of this court that the factual situation in the case before you is drastically different. And you must be careful, you should be careful that it behoves you actually to set new standards and create jurisprudence in this court because of the special opportunity you have had to deal with a very special case. What is the background of this case, Your Honors? Of course, the historical context of this case has already been very comprehensively given, and I don't want to go into detail. And the only thing that I can say, Your Honors, is that we do submit that this case cannot be properly evaluated without addressing the issue of Mr. Ongwen's complex political victimhood. The complex political victimhood that Ongwen went through. According to the evidence before you, Joseph Kony, in his delusion, thought he was fighting a political war to remove the government of Uganda. It is clear, Your Honors, from the testimonies of many witnesses that the political objectives of Joseph Kony to overthrow the government of Uganda was not clear to anybody, including Dominic Ongwen. We kept on changing his position, and then at the end, it was clear that he was there for his own survival. But in order to survive, as the saying goes, if you want to go quickly, go alone. But if you want to go far, go with others. On the basis of that, Your Honors, Mr. President and Your Honors, we submit that Ongwen should not be found liable, and the reasons shall follow. I respectfully refer Your Honors to the remarks of the remarks of the presiding judge at the opening remark. At the opening session. He said at page 1. This is to be found at real-time transcript 24 to 25 on page 1. On page 7 and 8. He said, this referral was understood to extend to the entire situation in northern Uganda, regardless of who committed the offenses under this investigation. Your Honors, we would have realized that to date, your counsel has not been hearkened. Your Honors, after this further reminder today, will the prosecutor emerge from our slumber and deafening silence about this and have the guts to hearken the hues and cries of the people of Acholi, Lango, Teso, West Nile, and indeed of the entire caring Ugandans and other peoples of the world to institute investigations to extend to the entire situation in northern Uganda, regardless of who committed the offenses within the charged period. Otherwise, Your Honors, the question is, will the prosecution allow this court to administer justice to all, instead of hiding behind the smoke screen of high-sounding cliches in this court and meaningless cliches, of course, used in this court? The people of Uganda and the caring international community are yearning for justice out of the situation that emerged in Uganda. It takes two to tango. One is here. Where is the other? Mr. President, I'll talk about the novel theme of escape. It has been made appear like it was a pick and go. Escape in the situation of the LRA to begin with varied from one person to another, depending on the focus an individual attracted from Joseph Kony. It was not an easy affair. I'll refer you to what D1 133, a child soldier expert, and the former child soldier himself. He testified that having interacted with former LRA child soldiers, there were no known cases of escape by child soldiers from the LRA. He coherently maintained that most of the children who finally came back home were actually recovered after battles with the UPDF. And others escaped under varying non-voluntary circumstances. It is being suggested that it was very easy for Ongwen to have voluntarily escaped. Notwithstanding the peculiar position they themselves sometimes allude to, that Ongwen appeared to be a special child because of all the children abducted at his age. There was no evidence that any of them rose in rank and command position the way Ongwen did. And the prosecution sneerfully suggests that this was all because he was a very brutal man. Your Honors heard from this courtroom the person that Dominic Ongwen was. Your Honors heard that Ongwen sometimes went to pains to protect the civilian population. Of particular reference is the case in Lukodi, where evidence has been laid that after he had sent his soldiers to go for food at Gwangdia, but ultimately he heard on the radio, FM, Mega FM radio, that his soldiers had been involved in the attack on Lukodi, and that people died. He rebuked them seriously. This is on record. Your Honors, this is not the character of a brutal man who would have earned his promotions and rise in rank to his brutality. The contrary is true. So we rubbish what was said in paragraph 507 to 5015 of the prosecution brief. And it was also suggested that, you know, after the cessation of hostilities agreement, which some of us drafted in Juba, and that window that was created under that cessation of hostilities agreement, Ongwen had an opportunity during that RV where he met Colonel Baliko Dembe, who allegedly offered, actually they say gave him an amnesty. Of course, you know, Your Honor, that Baliko Dembe was not empowered to give amnesty. He may have offered, But remember, Your Honors, that this is an untenable proposition. Because at this time, the important thing that the whole world, including the civilized world, and even America, which was at the beginning reluctant to get involved in that peace talk, had already gone to that peace talk. And there were all signs that it might succeed. When it had already been in the bush for more than 20 years. Why would it be contributory to the collapse of that opportunity? That is number one. And remember that the scene that they're talking about was covered by people who had been sent by Joseph Kony to oversee the evacuation of the forces from Uganda. Can you imagine what would have happened if Dominic Ongwen had attempted or even shown signs of escaping? There would bleed, first of all, bloodshed, and I can assure you that would be the end of the peace talk process, which some of us are so proud about, because although it was not finally fully implemented, people of Uganda, some of whom are in the gallery here, will recognize that because of the stroke of that pen, Joseph Kony was prevented from coming back to Uganda, and the situation of Uganda has changed. I know that I'm a concerned citizen of the world, and I would not want other people, people in other parts of the world to suffer. But at least I can say, with a lot of pride, that that peace talk helped the people of northern Uganda who had been under grips of terror from both the LRA and the government of Uganda forces for more than 20 years. They now rest. And Mr. President, you see, it's not as if Ongwen did not try to escape. One very poignant occasion is the occasion when while he had opportunity, and this opportunity, I want this to be put in context. In the LRA, it was always a question of opportunity. And in the case of Ongwen, when was the best opportunity that presented itself to him? The answer is, Your Honors, the best opportunities was, like in the case of many others, was when he was in the sick bay. I think Salim Saleh found time to contact him, well, from records, Dominic Ongwen sent some of his soldiers to go and make contacts with Salim Saleh. Unfortunately, I think he was let down. And, this was discovered to his detriment, and that changed the course of his life completely. I'll address it later. But the important thing that I want to ingrain in the minds of this court is the fact that, because of that one single incident, Dominic Ongwen was never free again. And this is captured from the UPDF intelligence report, UGA OTP 0255 0943, which reported thus: Major Domi is under surveillance following his involvement in peace talk contacts with Lieutenant General Salim Saleh. Commander Domi narrowly escaped firing squad when he reportedly received some bags of money from Saleh. So he was now under surveillance, and it was known even to the UPDF. Unfortunately, our colleagues on the other side were not magnanimous enough to disclose this as exculpatory evidence to the defense. Mr. President and Your Honors, I'll touch briefly on the prosecution closing brief. I regret, Your Honors, to have to say that the prosecution did a very shoddy investigative job in the case before you. Instead of combing the villages of the affected areas of northern Uganda, for credible witnesses, the way we did, it is obvious from the amount, the nature of witnesses you saw in this courtroom, that they basically went and sat in the comfort of their hotels in Gulu and collected only evidence from government security agents. And the most trusted person to connect them was Ochira, a colonel in the UPDF. How can you rely on evidence collected by a colonel working for a government, which would go to any extent to ensure that somebody is found guilty? Your Honors, can you consider what went in the minds of former abducted people who were now under the superintendence of the UPDF and the government of Uganda, in which Colonel Ochira played an important role? Were they coming to say anything other than what they thought would please Colonel Ochira, or rather, what would not compromise their security? They would not tell you this. Even under serious cross-examination, they would not disclose that. But it's a matter of consideration, Your Honors. I have my own value system. I'm sure you have your own value system. But it is worth reminding you, Your Honors, that wherever you find the hands of Ochira, Colonel Ochira, in the collection of evidence, rubbish that evidence. It is unreliable, its integrity cannot be without stain. Of course, I've already referred to the dog-eat-dog phrase. That was very interesting. And consider that, the community of northern Uganda had just emerged from a traumatic period of war. Members of that community, any member of that community in front of a colonel, and you expect him to say otherwise than the colonel wants him to say? No. He frightened them just like that convict who escaped, for those who liked literature, in the government inspector, who, cowered a child into, going to bring him rum, going to bring him food, because he said, for me, I look still better. There is a man in the bush. If you saw him, I look like a saint. If you don't bring me a file, if you don't give me food, if you don't give me this, we shall get you wherever you are. That is the picture I want to draw. The people of northern Uganda in front of a colonel felt that way, they would still be found. If they behaved silly, they would still be found. For instance, Your Honors, wasn't it important that the prosecution should have actually gone to any length to know the person they were bringing to court, to search his background, to know his age, or do something about assessment of his age? Nothing like that was ever done. And I can assure you, the prosecution relied on literature from other sources rather than doing their own investigation. We did it. And you see, the other thing is the issue of sexual and gender-based violence, crimes, is so crucial in this case. Prosecution should have done something about a background check, what happens in that community. Now, I don't know where, but although I'm happy that they admitted, but I don't know where they got information about actually traditional marriage ceremonies. These are some of the things that they should have done. Because they were saying, these people got married in the bush. But yesterday they said, no, you know, there were no marriage ceremonies, which now validates our case theory about sexual and gender-based violence, that there was actually no marriage in the bush. And since it was for them to prove that there was marriage in the bush, and they now say there was no ceremony, there was no solemnization of any marriage in the bush, therefore, how can they turn around and say, among other crimes, although it is not provided for in the Rome Statute, there was forced marriage? I persuade you, Your Honors, to expunge that charge from the case. There was no forced marriage because, first of all, it was not provided for, it is not provided for in the statute. And the statute restricts, of course, they're relying on Article 7, 1K, to extrapolate that provision to include forced marriage. Your Honors, if a careful reading of that section, of that article, and then the elements of crime which is expounded on it further, shows that if the intention of the framers of the Rome Statute was that forced marriage should be, one of the crimes, they would have explained it in the element of crime. This was not done. I ask you to expunge that. And, Your Honor, there is an interesting reasoning. The way the prosecution reasons back and forth about some of this is very laughable. They admit that Mr. Ongwen went through hell in the bush. Of course, these are my paraphrasing. Went through hell in the bush and was turned into a devil. But later, they turn around and say, nevertheless, he emerged from hell a complete saint. He is a saint and should be judged on the basis of a reasonable man of course, I'm not going to hazard any definition of a reasonable man. When I was taught by some English law professor in my first year at the university, they said a reasonable man is a man who walks on the streets of London. Of course, that kind of definition is untenable. In this case, we are talking about a reasonable man in the circumstances in which Dominic Ongwen, as a child, was subjected. Not for a few years, not for 10 years, but for 26 years. And they continuously refer to abduction and use of child soldiers and sexual crimes, sexual and gender-based crimes as institutionalized policy matters of the LRA, issued to all units as standing orders. Your Honors, you don't kill a messenger. You don't kill a messenger. You look for the principle. And they applaud the manner in which, you know, Ongwen went out extravagantly to, you know, to implement those policies. And they use the word implement. Your Honors, I want you to address your mind to this. Because we are talking about principal-agent relationship to some extent. In this case, we have already said, in the LRA, there is no such a thing like having an Army Council meeting to decide on any major operational matter. That was the preserve of coin. As a matter of fact, the only institutionalized organ of the LRA was the Council of Spirits. And the medium between the Council of Spirits and the humans, who were the handmaidens of Coin in the war, was Joseph Coin. Joseph Coin was the alpha and the omega of the LRA. His word was law, and you defied it to your own detriment. Your Honors, it is being suggested that Ongwen should have defied such a man. We are saying, Your Honors, that, you see, Ongwen operated with very limited options. In the closing brief, we put together what we think are extremely serious pitfalls in the prosecution case. We raised the all-important issue of fair trial violations committed by both pre-trial and, with due respect, the trial chambers, as well as the prosecution, which, if proved, would send the case to a stay of proceedings. And we say this without our tongue in the cheek. We are being, you know, intimidated yesterday that that is not an area to go. No, we insist that some of these are serious. If you don't give somebody sufficient notice to prepare himself, how do you expect him to, you know, be here? I mean, to defend himself effectively. In paragraph 1, the prosecution validated the defense case theory based on Mr. Ongwen's statement at the beginning of the trial. I am not LRA or Joseph Coin. And Your Honors will remember that when you asked him whether he understands the charges, Ongwen said, no. As far as I'm concerned, I only understand it to the extent that it relates to Joseph Kony and LRA. That is not the understanding upon which somebody would be put to trial. That is unequivocal. The man is saying, this confuses me. How is it that I am before this court? And so, in other words, I think he was not sufficiently notified about his personal role. And as you can see, Mr. President and your honors, the charges before this court were a product of a fishing expedition. And this counts for the confusion, and they said we are confused. They made some comments that the defense is confused. We are not. Actually, the reverse is true. It is the prosecution who got it all wrong and got it confused. Because if you look, your honors, at the charges, the pleadings in the warrant of arrest, they're drastically different from what is before you. If you look at the charges that were for the entirety of the LRA, the 5 LRA commanders who were there, most of them pointed to those who were over Mr. Ongwen. But then, finally, when it was Ongwen who found himself in this courtroom, they behaved like the proverbial coward who feels hungry for a fight when he sees a weakling. They are now hungry for a fight because when he's a weakling, they cannot have hold of Kony, they cannot have hold of Odhiambo, Vincent Oti, and the late. All this should be put in context. We are begging, we are praying, your honors. The charges were basically meant for senior commanders of the LRA. And they talk about attacks of civilian targets. And before I go to that, I want you to listen to this. The prosecution said between July 2002 and December 31st, 2005, the Lord's Resistance Army victimized thousands of innocent civilians in northern Uganda. This is their statement. Now, if this is their statement, where does Ongwen fall in? Where does Ongwen fall in? As I said before, Ongwen was just a mere handmaiden of LRA, who, as we have also said, was always acting under duress. And the attacks, they say it was widespread and systematic. Your honors, evidence on record show that the attacks was parodic. As a matter of fact, they were sporadic. Rather than widespread and systematic. And this is a requirement of the law. They should have proved beyond reasonable doubt that, first of all, it was the civilians who were targeted. Secondly, that the way it happened, it was systematic and widespread. But you know, if it was systematic and widespread, they would not have only picked on 4 crime scenes within this period. Because we are not talking about the Lagile, we are not talking about Kochongaho, we are not talking about, Adilang and all those kind of things. We are talking about the charged period between 2002 and 2005. Your Honors will agree with me that if this thing was widespread, they would not have just brought 4 crime scenes. And at the background of that, Your Honors will remember that the assignment, the missions of the LRA was about food and other supplies of necessity. And at this point, I want to say that even the charge of pillaging falls flat on its face, because the definition of pillaging under the Rome Statute requires them to prove that those properties, the things which were taken, were not necessary in the circumstances. But we say that when they came back from Sudan, everybody in the population from whom they would go and beg for food had been herded into IDP camps. These people were left with the devil's choice. The choice between holding back and dying of hunger, or doing everything possible, even at the risk of contending with the UPDF soldiers who were guarding the camps, to go and get that food. It was in this context that they went. They went to look for food. But in order to get the food, or to get to where the food was, they had to contend with the UPDF and their auxiliary forces, some of whom were right in the middle of the camps, because many people in the camps were collaborators, as has already been elaborated by many witnesses. So it was in the course of this confrontation between the LRA and the UPDF that members of the civilian population became collateral casualties. And being collateral casualties, who died in the crossfire, there is, and I must say this at this point, the shoddiness with which the prosecution made their investigation is crystallized in their failure to even request for forensic evidence. But the minor one, which was done in Lukodi, for instance, gave very instructive information about how actually death occurred in the IDP camps. Forensic evidence from the Lokedi situation found, Your Honors, is on record that there were big bomb shells near the IDP camps. While on the other hand, small shells for small guns, AK-47 and so on, were found near the barracks. Which means near the barracks where there was engagement between LRA and the UPDF, the LRA fought, and evidence of their fighting was found at the barracks. But where you find the big bombshells, evidence, the only reasonable inference would be that those bombs were thrown by the UPDF, and who killed people, therefore, at Lukodi. Your guess is as good as mine. But remember, Your Honors, that those who went from the senior brigade finally went back to Dominic Ongwen and told Dominic Ongwen that there were no deaths at Lukodi. Meaning that, they had no reason not to tell him, because death was not a frightful thing to tell a commander. But the reason they didn't tell him was because by the time they left, there was no death. Who killed them after the LRA had gone? These are some of the things from which you can draw inferences, Your Honors. Your Honors, the question of Ongwen's position of authority has been dwelt on by the prosecution very extensively. They say that Ongwen's position of authority and control within the organized and hierarchical structure of LRA. Mr. President and Your Honors, the prosecution relies on evidence of about 20 witnesses of various background and roles in the LRA to prove Mr. Ongwen's position of authority. Their case theory is that during the charged period, LRA was an organized and hierarchical structure with all the features of a formal army. I have this to say. Yes, on paper, that may be true. But in fact, that was not true. The LRA is basically about spirit control. Control of the forces through alleged spiritual spirit medium. And that medium dwelled in only one person, who was the alpha and the omega of LRA. That was Joseph Kony. LRA did not operate according to conventional military orders or instructions. While in the military, the formal army, the commander-in-chief calls the army council and discusses the strategies. First of all, agree on whether or not to go on an operation. And then they would discuss the strategies. But in the case of Kony's LRA, Your Honors, you heard that Kony would consult his council of spirits. And the things that came to the commanders and did not have, and in any event, those orders did not have to go to the next person, to Kony, then to the next, to the next. It is true, Mr. President, that when he so chose, Kony would follow some form of chain of command. But when it was inconvenient to him, he did not. And I dare say, Mr. President and Your Honors, that in the case of the charged crime locations, Kony was the wiser, much the wiser, for following the orders of the spirits. He went directly to commanders that he preferred and circumvented Dominic Ongwen. Your Honors will find that in all these situations, there is some gray area somewhere. There is some gray area somewhere. And especially with the presence of people like Lapaicho and then Ochan Labongo hovering in the wings around Dominic Ongwen. These were confidants of Joseph Kony. We have been bringing evidence to show that rather than go to Dominic Ongwen, who was the de facto brigade commander, you'd find that Lapaicho was somehow there. In the case of Odek, where Kony actually wanted somebody to, to his people to be taught a lesson for behaving lousily, he chose somebody else. And the reporting on the so-called intercept, which we have rigorously contended are unreliable. You know, when you, in criminal matters, we're dealing with the life of somebody, just like any other person. Yes, if he's found guilty, so be it. But before being found guilty, the standards have been, the bar has been set very high for the prosecution. You must prove the charges beyond any element of doubt. Your Honors, Ongwen always acted on superior orders. Ongwen, Your Honors, you know, in the LRA, like I said, it was on paper, yes. But in fact, it did not work. Because Kony, to a great extent, was a copycat. Evidence was brought before you, Your Honors. That, you know, whenever President Museveni promoted people in his ranks, including himself, Kony did exactly the same. When President Museveni was a lieutenant general, Kony made himself a lieutenant general. When President Museveni finally made himself a general, Kony also promoted himself to a general. There was a time when UPDF did not have divisions, LRA also did not have divisions. But as soon as, you know, President Museveni made arrangement to cascade his system up to the point of a division, Joseph Kony did exactly the same. He also created divisions. And you see, Your Honors, I want to convince you that all this was done merely for public relations purposes, but not to tie Joseph Kony to, you know, submitting himself to the chain of command. And it should only be interpreted as such. And the other thing I want to say about this is that you know they're saying by the 21st, was it 21st of July, 17th of July, Dominic Ongwen had already been appointed deputy brigade commander. But you know, on the 21st of the same month, there is a document that was authored by the government of Uganda, by the UPDF, listing 68 most senior commanders of LRA. Dominic Ongwen is significantly absent from that list. But more importantly, Your Honors, on the 22nd of July, it is alleged that Vincent Oti had a radio communication with Joseph Kony, where Joseph Kony asked him about those who had not been deployed senior commanders, commanders who had not been deployed. Dominic Ongwen was one of those who were mentioned. Now, if by 22nd, Dominic Ongwen had not been employed, can they tell us how far back Dominic Ongwen had not been employed? This strongly suggests, Your Honors, that you should believe our story. Of course, considering the totality of the situation around Ongwen at that time, that for the whole of 2003, Dominic Ongwen was inoperative. There is this ridiculous proposition that by the 6th of December, Dominic Ongwen was already up and operating. But Your Honors, Dominic Ongwen got very serious injury on the 6th of November of 2002. You saw Dominic Ongwen here. He has a shorter leg on that, limp. They shot him and they seriously damaged his bones, fractured his bones, some of which got lost, and that is why his leg is shorter. I think to suggest that less than 1 month later, he was up and operating is rather insensitive. Even with the highest technology in orthopedics, nobody can convince me that a man who got that kind of injury would have been up and operating within 6 months. Mr. President, I will ask Chief Tako to, address you briefly before we go to lunch. Thank you.
Thank you. Mr. Tako, please.
Your Honors, permit me very briefly first to extend my appreciation to my learned colleague, Manuba and Francis Koch, for acknowledging the status of victims of defense witnesses. That's what all true professionals are supposed to do before the court, international court. Learned senior lead counsel has already submitted on the scope of the case that you defined when we started this case. This case is not about Sudan or action that took place in Sudan or took place in Congo. Obviously, it's not about isolated acts. You heard the submissions quickly about the wives. We take note that paragraph 160 and 174 of the prosecutor's brief, the prosecutor has already at least accepted that a lot of the evidence of these women were outside the time frames of the court, and that they will only use it for context. And of course, the examples that my learned colleague cited about the wives, Article 56, most of it you see occurred in Sudan. But what is important about this is that the prosecutor also submitted that even when adoption of women was allowed, according to them, the same as Ongwen adopted women. In paragraph 104 of the amended arrest warrant pleadings, Mr. Coney outlawed, banned the adoption of women in senior brigade because Abu Dema had committed some violation regarding the women. We punish the whole. And we submit, Your Honor, that Dominic Ongwen did not, there's no evidence to suggest within the charge period he adopted. The evidence of the wives, which will contest vigorously, they themselves, from their own statements and from the pleading and from the submissions of the prosecutor, they said were outside the time frames. Nevertheless, for one instance, even if it were to be true, which we contest, that Ongwen dared or disobeyed Joseph Kony and took upon himself outside the policy and the structure of ARA and committed these crimes, including the one of hiding a woman under the bed, there is no gainsaying that the policy element is lacking. The context of the war crimes and the context of the crime against humanity are lacking. They become isolated incidents outside this policy structure within which the charges are laid. We are confined to the confirmed charges as well, and we must also look at one other incident, Your Honor, that with regard to the charges are laid, and with regard to the contextual elements, where they are not pleaded, the prosecutor cannot invent some along the line in their submissions by saying, even though the adoption of women took place out of a time frame, they should be used as context. They are not pleaded. The second point I will make, Your Honor, very quickly, is that the prosecutor yesterday, paragraph 100 and 101 of the rare transcript said that the precise location of RFV did not matter, and that was not pleaded, and it was not even required to be pleaded. In that case, Your Honor, if you believe the prosecutor, then we urge that the crimes related to the planning and other crimes that were alleged to occur at the RFVs should be dismissed as a matter of law, because the location is not known. The prosecutor says it doesn't matter, therefore they could not have occurred in the abstracts. So the majority of these crimes are alleged to be in the RFVs. The next point, Your Honor, before I go to the main thrust of argument, goes to the fact that Mr. Ongwen, as the charges are laid, was not alleged to have committed the crimes alone. They said several brigades, or a number of brigades occurred, and there were task forces. And these task forces could only be constituted by Joseph Kony. Yeah, sorry, Your Honor.
Mr. Tako, we had this the past 2 days too. Please slow down a little bit so that the interpreters can follow.
Yeah.
Thank you.
Yeah. The task forces, Your Honors, there is no evidence that Governor Ongwen exercised control over Trinket brigades and the other brigades. Never, even as a battalion commander or either as a battalion commander in senior or a brigade commander. They were controlled directly by Joseph Kony. And the spotlight here is Dominic Ongwen. What happens? His participation alone, mention of Dominic Ongwen alone, without bringing the spotlight on these other brigades who were in the task force, makes the case to collapse. In particular, as a matter of pleading, they said Dominic Ongwen and other leaders. And the identity of these leaders, Your Honors, has not been brought to attention. Indirect co-perpetration and other form of liability, you need an agreement. You need to show the identity of the other people, the participants. But this is not the case. They haven't, either as a matter of pleading or as a matter of evidence. And in any case, the prosecutor, in order to obviate the pleading requirements and the notice violations, they now, in their brief, have characterized the fighter as Dominic Ongwen's fighters. No longer ARA fighters, but Dominic Ongwen fighters. You see systematically in their brief. They've created a new category, which is not in the pleadings, is not in the evidence. That said, Your Honors, within the time that is left, if I'm quiet, let me get to my paper quickly and try to make my point as fast as possible, since my time is very limited. Your Honors, if listening to the prosecutor and the victims in this case, my worry, and that Mr. Ongwen, is that if Your Honors accept the narrative that we had these few days and the changing theories of the case floated by the prosecutor, there will be only one winner, and that winner will be Joseph Kony, whose invincibility this process must have eternalized in the spirit of the victims, in the spirit of the people of northern Uganda, and it will send a wrong message to the world that child soldiers, whom the Rome Statute architecture was intended to protect, are on their own. They can be sacrificed for political expediency or to excuse inability to bring Joseph Kony to justice. that will be very, very sad indeed. Victims and true victims and all the victims, and I can say everybody in northern Uganda is a victim. It is not just some form of victim that constitutes an opportunity for some form of activism. It is rare victim, rare human beings, all the participants in this case. And I can say, Your Honors, with due respect, that Dominic Ongwen is a victim. It's unfortunate that in the pre-confirmation pleadings that the defense filed, they raised the victim status of Dominic Ongwen, among other violations, other objections. The Presiding Chamber dismissed it without any reasoning. And the prosecutor did not accept the victim status of Dominic Ongwen until the opening statement, which is accepted, but said that she was a victim perpetrator. So the notion of victim perpetrator was introduced in this proceeding for the first time in the opening statement by the chief prosecutor. Yet, the victimhood, the victim status of Dominic Ongwen was an issue that was brought to the procurator judge, who completely dismissed it without reasoning. That was not just a fair trial violation. It was a denial of fair or due process in a case in which the status of Dominic Ongwen is important. And you find in the arrest warrant that the prosecutor merely said Dominic Ongwen's origins are unknown. And the charge against Dominic Ongwen were confirmed as a competent adult without considering his own objections and the objections he raised as to the competency to be tried at that point in time. He has litigated some part of it before, Your Honors, but it was an issue which the procurator judge completely ignored. Your Honors, I would not dare to go into the question of mental health. My colleague will deal with that. But one key issue, Your Honors, must look at is quickly the question of the evidence submitted through bilateral motions. This ISO intercept report that the prosecutor has relied heavily on. Now, one critical thing, Your Honor, is that it is not, the prosecutor has not explained why they were required to rely on evidence that was submitted through bilateral motions to secure a conviction. That was not to prove acts and conduct charged. The purpose of submitting evidence through bilateral motion is completely different. And even when the prosecutor had called witnesses, fact witnesses, you must assess the evidence with the witnesses with caution because of their own criminal involvement admitted. Now, let me take one witness, 205. 205 admitted that he told Ongwen, when inquired from him, whether there were casualties in Lukudi. He said no. Even though Ongwen had said over the radio, he consistently said no. Every person when they were involved, they told Ongwen no casualties. Either the casualties were unknown to them or they lied to Ongwen. Now, this evidence of these prosecution witnesses goes to show that the main rear Ongwen, or even the actus reus asking him to go to Lukudi cannot be proved because P18, who came from another unit, testified that Ongwen said he should go to Gwendia, as lead counsel has said. A certain Rod Orak, the prosecutor admitted in the brief that he was a collaborator of Joseph Kony. And you had evidence that he took back someone who was fleeing and helped him to take him, for him to escape. He took him back to Joseph Kony. We had evidence from Ru 68 P15, one of Luala school girls victims, was distributed to Vincent Oti. That Vincent Oti placed a call to Remark and also to a military commander in Pajule, and also to a certain Lachambert, informing them that it was coming. And therefore, he had an opportunity to incriminate Dominic Ongwen to excuse his own criminal involvement in the crimes that occurred. He cannot be believed. But apart from that, the only time that Remark said something which you could take seriously, it was outside the context of the crime, or alleged crimes. Describing an event that occurred before the actually cultural leaders, where he saw Ongwen. He said Ongwen was demonstrating and crying. My education had been ruined, moving up and down like a madman, devastated. And the inference, hoping to impress the cultural leaders. The cultural leaders would put pressure on Joseph Kony to make sure peace return, so him and fellow victims will return to their country to rebuild their lives. And you see this systematic conduct by Ongwen supporting the peace process all along. When you come back from break, from the time I will expatiate on this and some other points.
You rightfully addressed the break, Mr. Taku. We will have now the break until 11:30.
All rise. We will